We will go on the record in the matters 24 CF 150, 24 CF 250, 25 CF 21, 25 CF 84, and 25 CF 113. State of Wisconsin versus Aaron Benjamin. The state appears through District Attorney Kevin Schmidt in person. We have Aaron Benjamin in person with his counsels Renee Landgraf and Nicholas Davis. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement, a global agreement in these cases. Who would like to recite it, Ms. Landgraf or Mr. Davis?
Your Honor, I'm only appointed on one case, and that's 25 CF 21. And
I can recite it if you'd like, Judge.
Okay, please do.
Your Honor, in 24 CF 150, Aaron will plead guilty to count 4 disorderly conduct. In 24 CF 250, he's going to plead guilty to count 4, which is obstruction, Your Honor. And I don't want to speak for counsel, but I believe in 25 CF 21, he's going to plead to count 2 and OAR. And my understanding is on the 24 CF 150 disorderly conduct, it would be 90 days jail, credit for time served of 120 days, a time period from 7/1/24 to 10/28/24. On the obstruction, Your Honor, which is 24 CF 250, it would be 2 years probation, stayed and imposed 6 months on the obstruction. And then with regard to the 25 CF 21, the operating after revocation, it's my understanding that would be it would be state imposed 30 days. And I don't know what the probation period is. Conditions would be AODA assessment, follow through, domestic abuse assault assessment, get a valid license. And if he can get the license back, he's eligible for discharge early on the operating after revocation, Your Honor. If he completes the AODA domestic abuse assessment follow through, he'd also be eligible for discharge early on the probation as well. That's what I believe the agreement to be.
All right. Basis for the agreement in the public interest, Mr. Schmidt.
And Judge, the reason most of these are felonies is from the very first case, which was, you don't need much to charge the felony inflicting cause bodily harm on a child. Looking at the totality of the cases, what they really show is Mr. Benjamin consuming alcohol in, I believe, every single one of these events and acting out aside from the OAR, which is just like a different criminogenic need. So the goal of this is to place him on probation for 2 years with time hanging over his head and then deal with the AODA. If Mr. Benjamin were sober, none of these offenses would have happened.
Thank you. We are in victims' rights compliance. Are we having any statement here today, Ms. Bauer? Not tonight. Okay.
Your Honor, I just need to interject for 1 second. I think when you called the cases, you called 2 other 25 CF cases.
25 CF 21, 25 CF 84, 25 CF 113.
Are those 2 being dismissed and read in along with yours?
I thought Kevin, those would be dismissed and read in, weren't they? Those
Yes.
Yes.
The brand new ones?
Mm-hmm.
Okay.
All right. So all of them are going to be dismissed and read in. Okay. All right. So, Mr. Benjamin, that is the agreement that you've reached?
Yes.
And I have in front of me the plea questionnaire waiver of rights form for both of them filled out by each of your attorneys. Did both of your attorneys go over these documents with you thoroughly?
They did, yes.
Did they both go over them with you essentially word for word?
Yes,
And do you understand everything on these documents?
I do.
Did you sign both of these documents?
I did, yes.
And so you're stating here today that you are 40 years old and you have 10 years of schooling. You do not have a high school diploma or equivalent, but you can read, write, you understand the English language. Is that correct?
Yes,
No mental illnesses or disorders, but you have had blood pressure medication, but nothing else?
yes, that's correct.
Did both of your attorneys go over your constitutional rights with you?
They did, yes.
Did they go over them thoroughly with you?
Yes,
Do you essentially understand them entirely?
I do.
Do you need me to go over those with you in any more detail?
No,
Do you understand that by pleading guilty, you're waiving and giving up these rights?
I do understand.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation?
I understand.
Do you understand that with regards to the disorderly conduct in 24 CF 150, the state would have to prove that on or around July 1st, 2024, that you in Burnett County, while being in a private place, engaged in abusive, violent, unreasonably loud, or otherwise disorderly conduct, which tended to provoke a disturbance. Do you understand what the state would have to prove?
I do, yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
Yes,
And do you understand that with regards to the 25 CF 21 case in which we're pleading guilty to count 2, the operating after revocation, do you understand the state would have to prove on or around January 24th, 2025, that in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked, you were operating a motor vehicle on a highway during such revocation period or thereafter, and that revocation was a result of an OWI or similar offense. Do you understand what the state would have to prove?
I do understand, yes.
Do you understand that upon conviction, you face a fine of up to $2,500 or imprisonment of not more than 1 year in the county jail or both?
I understand.
Do you also understand that with this, the court may suspend your driving privileges for not more than 6 months?
I understand.
Do you understand that with 24 CF 250, that would be the obstruction charge, the state would have to prove on or around December 7th, 2024, that in Burnett County, Wisconsin, you knowingly obstructed an officer while the officer is doing an act in an official capacity and with lawful authority by failing to obey that law enforcement officer's commands. Do you understand what the state would have to prove?
I do, yes.
Do you understand maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both? Do you understand that?
I do, yes.
Do you also understand that there is an offer that's been presented and an agreement that's been reached between both sides, which would be a straight jail sentence for the disorderly conduct, 90 days of jail with 120 days of jail credit, with the obstruction, 2 years of probation with an imposed and stayed jail sentence of 6 months, and with the OAR to be on that probation and to have imposed and stayed 30 days with certain conditions on probation. So, Mr. Benjamin, do you understand that I'm not bound to follow that agreement?
I do understand that.
Said differently, that I could sentence you all the way up to the maximum possible penalty for these crimes if I thought it was warranted,
I understand, yes.
or I can do any other sentence that I feel would be appropriate given all of these cases, and it could be one sentence for one of the cases, one sentence for the other, and one for the other, and I could have them all be consecutive, and I can impose them for today. Do you understand that?
I do, yes.
Do you still wish to proceed and enter guilty pleas?
I do, yes, Your Honor.
Now, did you go over both of the criminal complaints with your attorneys?
I have, yes.
And essentially in those criminal complaints, it says what happened those days and why you were charged with the crimes. Do you remember that?
Yes,
As it relates to the 24 CF 150 and that disorderly conduct, did you go over that complaint and those facts with your attorney?
yes,
And are you admitting here today that you in fact did engage in what would be defined as disorderly conduct in the state of Wisconsin?
yes,
In 25 CF 21, the operating after revoked, did you go over those facts as alleged in that complaint?
yes,
And are those facts essentially accurate?
yes,
Are you admitting here today you operated a motor vehicle after a revocation?
yes,
In 24 CF 250, the obstruction, did you go over that criminal complaint and those facts alleged in that complaint?
We did, yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did obstruct an officer by failing to obey that law enforcement officer's commands?
Yes.
Has anyone made, well, first I'm going to ask Ms. Landgraf, may the court use the probable cause section of the criminal complaint in your case to find a factual basis?
Yes, Your Honor.
Same question to you, Mr. Davis.
Your Honor, in both cases, the defense will stipulate some factual basis of both criminal complaints to rise the level of conviction.
Thank you. Has anyone made any threats or any promises to you, Mr. Benjamin, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Have both of your attorneys represented you competently
They have, yes.
and they've answered all of your questions
They have,
and they've looked at these matters thoroughly?
yes.
Are you satisfied with their services?
I am.
Any questions for the court or for your attorneys before I proceed?
No, Your Honor.
Then as to 24 CF 150, count 3 disorderly conduct. Well, actually, it's count 4 disorderly conduct without the domestic abuse enhancer. How do you wish to plead?
Guilty.
As to 25 CF 21, count 2 operating while revoked. How do you wish to plead?
Guilty.
As to 24 CF 250, count 4 obstructing an officer. How do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 3 criminal charges. The remaining counts in those cases and the other cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. So I've already touched on some of it and stating the public interest. Over the totality of these cases, Mr. Benjamin's already spent 120 days in jail. That's the July 1st, 2024 to October 28th, 2024. And the intent is for the DC to take credit for that. That's why there's the 90 days jail on that. 90 days jail with good time is that whole thing. Then with the 2 years probation, that gives us an opportunity to deal with the AODA issues, if there's any domestic violence issues, and to get his license back. Staying imposing, I think, reasonable penalties for those, given what those offenses are, with the 30 days jail on the OAR, which I know OAR could be up to a year in jail, but that's obviously not appropriate for this case, and 6 months for the obstruction, which is largely in part because of all the read-ins. Thank you.
All right, Ms. Landgraf.
Thank you, Your Honor. This is an OAR. I think placing him on probation with an opportunity to get his license is appropriate here. I would note that although I don't represent him on the other counts, I was his attorney on the underlying revocation, so he did serve some additional consequences outside of this agreement.
All right, Mr. Davis.
Thank you, Your Honor. Your Honor, so I'll just start off. I think that any criminal conviction is a serious offense. I know that lawyers like to downplay it. It's just a misdemeanor or it's a low-level felony. He doesn't need to keep racking these up. These aren't a badge of honor. And I know that Aaron's a little bit sick of going through this. Now, I've known Aaron for a long time, and Your Honor, I know that you've probably known him much longer, and you've seen him in your courtroom multiple times. And so I think the issue with Aaron is drinking. I don't think he's an individual that can go and have a glass of wine or have a beer with dinner or watch a game. I think sometimes if he goes out, it's that one turns into a bingy habit. And that's just how people are sometimes. So I think Aaron is going to have to keep that in check. It's something where he may want to consider not drinking. And I think that his life will be very fulfilling. It already is fulfilling. He's got children. His significant other is here with him. And I just found out they've been together for 13 years. And he needs to stop dragging his feet. He's still not proposed to her, but I think that will happen when he is finished with this. I want you to know, Judge, that he's always been very responsible, respectful with me. Any appointments I've had, he's always kept them. He's always been involved in his cases. And so I'd ask the court to consider the joint recommendation. I think the need to protect the public will be met with regard to him not drinking and following the rules of probation. And quite frankly, I hope that he does what he's supposed to do so he can be discharged from probation, because I know that annoys him. He doesn't like it. He's even made a comment with the attorneys today that officers are looking for his vehicle. Or is that Aaron? Is it Aaron? Well, I said, Aaron, if you have your license and you're not doing anything wrong, then you can tell the officers, yes, it's me and I'm driving the vehicle legally. And so I hope he gets to that point. I think he expressed to counsel that it's very expensive, but he just needs to save that money up and complete everything he has to. So I ask you to consider the joint recommendation. Thank you very much, Your Honor.
All right, question before I move on to Mr. Benjamin. You made a statement, Mr. Davis, that it costs a lot of money for him to get his driver's license. What are we talking?
Well, he had the money, but he told me that for all school clothing, they spent about $2,000 in the last week for school clothing for the children. So I think he's going to have that money very soon to do what he has to. So he's not
That's
using the excuse that he can get it.
No,
He just needs
That's
to.
great. I appreciate supporting your kids that's a great dad. How much money is it going to take for you to get your license? What are we talking, Mr. Benjamin?
I honestly don't know the answer to that. I don't have a number.
Who do you owe?
I guess I was just under the, I understood that I would owe some money to go get my license.
So I think, Judge, I think that he has cash on file, and after he pays all his fines, I think he'll have money to go to the DMV.
I want to control that though. I want to keep it. I want to know because I want to make sure it gets paid to whomever it needs to get paid to so we can pay off your fines and fees so we can get your license so you're one step closer. Because you're right, Mr. Davis, I have a lot of money in here. I have a lot of money that I know is sitting here that could go towards his license.
I think Aaron needs to make that phone call to find out exactly what it needs to do to reinstate that license. And maybe the court hold on to that money until he gets that number and we provide that to the court.
And Ms. Landgraf, as the attorney for the OAR, was that something you looked into or had him look into?
Your Honor, he was in jail up until like about a month and a half ago or so. But I did talk with him today. I mean, I asked him how much and he said that he didn't know, but he was going to find out.
We can find out because, well, with taking the plea, I could take all of it if I thought that it was egregious enough here and for a fine and take all of the stuff. I much rather see the money go towards a use, something, to get your license back, or if you have back child support or something like that. But that's not an issue that we're talking about here. It's simply getting your license and making sure that you do have the funds. And here, at least you have the funds. They've kind of been here in the little kitty of your case.
Your
Mr.
Honor,
Benjamin?
yes, the money that you have there is not mine. It was never mine. It was my brother's, like the bond money.
Well, it's mine now.
Okay, well, I was just saying it was never mine, so I never had that money in the first place. And
But the thing is when somebody bails you out, they sign this nice little sheet that says you understand that you're paying this money, the money the court can use for any purpose that the court finds to be associated with the crime.
okay, I understand.
So that's why I'm just saying it's money and you're going to owe your brother back regardless. Because I could take all of it today right now for fines and fees.
Right.
But that's not what I want to do. I want it to best benefit you and best benefit society and the community. And that's you getting your license.
Your Honor, for the OWIs I know that it's between $200 and $250 to reinstate that license. I don't know if he has to do an AODA. I don't know. I don't know. All I know is that I think the $200, $250 will help him reinstate that license.
Your Honor, now that the reinstatement too, and now that I think about it, I believe there was an interlock thing too, which I believe was going to be very expensive. So that was another reason that I don't have the exact number, but I know it costs a lot of money.
That's different. You do have to install that, but there's also a form here that you would fill out and I would sign off for a half price interlock device. Okay. And
Okay.
so you're going to need to do that. You're probably going to need to get that installed. You're going to need SR22 insurance. You may need to have that AODA assessment and follow through again. Those are all things. And if I know the things, then I can give you an idea of, I can probably guess right now in my head, at least for those things. But I don't know if you owe any other past due fines and fees that you have to pay to get your license back. Because some people have 1,000 tickets in Minnesota that they have to pay in order to get Minnesota to uncheck so they can get their Wisconsin license back.
So now would I have to pay for the interlock stuff when I don't have a vehicle?
You
in my
have to.
name, you still have to pay
You have to
whatever
get a
fees.
vehicle and it has to be installed. Yes.
Okay.
All right. So anything else you want to add, Mr. Benjamin, before I sentence you?
No, Your Honor.
Okay. So when this case first came in front of the court, in black and white, it's scary, obviously, because it had that child abuse intentionally caused harm, which is that H felony involving your family there. And if you dissect that case, as we did in the process of having these hearings, and that case was dissected, it wasn't as serious as that black and white portrays it to be. There was a serious incident that occurred. Your conduct was not appropriate. I think you've admitted that you were drinking. And when you drink, I believe not only did your attorney state it either not only here, but at another hearing, but you've admitted, when I drink, I tend to drink to excess, and I get a little out of control. And when you're with your family, that's what happened here. I can't remember if I involved your son, and I can't remember if involved playing a game or doing something, and it just escalated. Not that you wanted it to, not that you intentionally caused harm, or you like you took him and you threw him against the wall. You were just a little bit, because of the alcohol, a little bit more gruffy to him and I believe the rest of your family that day. When you're not drinking, Mr. Benjamin, and both of your attorneys have said it, but mostly Mr. Davis, you are a kind and caring father and significant other. No one knows the ins and outs of your relationship and your family dynamic. Nobody does, except for the people inside those four walls. So if you are able to be, kind and caring and giving when you're not drinking, then that is great. And that is what your family needs. Your significant other and your children do. You don't need to be engaged. You don't need to be married in order to be a family. You're a family. So do what you both want, and you both want there. Because as long as your children see that you are loving each other, you're supporting each other, and you're supporting the family and raising the children together, then that's a family, and you don't need that ring. So, but if you want it, push for it. That's all there. But Mr. Benjamin, I would love to see that you work a little bit harder on your drinking, on your alcohol issues, and then you won't need to be here.
This is the defining moment of the sentencing hearing. Notice that the judge is no longer debating whether these crimes occurred. Aaron Benjamin has already entered guilty pleas. Instead, the focus has shifted to what caused these offenses and how to prevent them from happening again. Under sentencing principles, judges often consider not only the offenses themselves, but also whether the underlying behavior can be addressed through supervision and treatment. Here, the court repeatedly points to alcohol as the common factor connecting these cases. Emotionally, the judge acknowledges Aaron's positive role as a father and provider while making it clear that those qualities are being undermined whenever alcohol becomes involved. Here's a question for you. Should courts prioritize rehabilitation when they believe someone's behavior can change, or should repeated alcohol-related offenses lead to harsher punishment? Keep listening, because the judge is about to explain exactly how that balance shapes the final sentence.
Which you've already sat. The disorderly conduct charge, I am going to assess $443 in fines and fees. With the OAR, I'm only going to assess $200, the DNA surcharge. With the obstructing, I'm going to order $443 in fines and fees. And so we will have remaining money here. If I can see. So there will be $1,900 that's sitting here. That if I find out you need an AODA assessment, then I can send that money to Aurora. If you need $250 to reinstate your license, I can send that to the DMV, have it directed for your use. Obviously, you said that you borrowed this from your brother. You don't want to exhaust all of it, but if it's something that you need to get your license back and to get it back as quickly as practically possible, that is the benefit. I know you're a worker. You're still working at the casino?
Yes.
Yes, you're a worker, you're a hard worker, you're a provider. As Mr. Davis said, you just spent $2,000 on your kids for school. Kids cost money and you're there and you're doing it. So I know that you're going to pay your brother back. I just know, I have that feeling you're going to do that. So what I'll do is I'll just keep this, but Ms. Landgraf, can you please update the court on what he needs to do in a written letter after Mr. Benjamin finds out? So that the court can direct the money where we need to direct that money.
Yep, Judge, I looked it up online here and it says that there's going to be a $200 reinstatement fee. Then the driving privilege is going to be restricted to the ignition interlock device. And then I believe he needs to do the, did you do the OWI assessment yet for the? And then the OWI assessment, it doesn't appear that he has any outstanding like fines or tickets. Just a quick search on CCAP doesn't appear that he has any outstanding traffic matters.
Okay. All right.
So I don't know exactly how much a OWI assessment is and
$300.
what it, $100
$287
for the OWI assessment,
Yes.
287 plus the $200 reinstatement fee plus the ignition interlock device, and then how much ever the insurance will need upfront.
Yeah, the SR 22 insurance, there's been a case where the individual found what they needed, and I think they need to pay 2 months, 4 months, or 6 months in advance with that. And then the court just sent the money to the insurance company. So we can do that here as well if needed. So the court will state on the record, we're going to keep that money for a period of 4 months and then determine where. Hopefully it'll be diverted before then. Well, on probation, AODA assessment, AODA, OWI assessment, and driver safety plan. So you have to do the AODA, OWI assessment plan. And so you want to focus on that OWI part because that's going to kill the 2 birds with 1 stone to get your driver's license back and then to be able to meet this condition, okay? So you want to make sure that you indicate that you want to do that OWI assessment, but I have to call it AODA/OWI.
Understood.
Do that domestic violence class. Have you done one with Dave Hatch yet? Have you done a class with Dave Hatch at Restorative Justice here?
No.
All right, so I'll just say the domestic violence class with Dave Hatch, Restorative Justice. Get your driver's license. I am going to put on there as a condition, at least right now, that you get your GED.
I have my GED.
You do?
He does.
I thought it was checked no.
I'm sorry, Judge, I checked the wrong box.
Okay, because I thought it was checked no. So right now I'm going to check it correctly and undo that and I'll initial. Okay, so never mind, you don't need to get your GED. I'm glad to hear that. That's much better. Okay, so that was the AODA, OWI, DV. Get your license. You have gainful employment, but no alcohol, no establishments that have the primary purpose for the sale or the service of alcohol. You may go to the casino, but only for your work-related purposes, at least while you're on probation. I am going to have that caveat and accept that from this, both sides, that with the OAR, once you get your license, then you can discharge early at the discretion of the Department of Corrections, okay?
Okay.
And with regards to that obstruction, if you meet every other condition and so you get your license, you do that assessment, you do the class, you do all that you need to do, then you can discharge early off of probation, again, at the Department of Corrections, at their discretion, okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. You'll go to the jail and you'll make sure that they have your DNA, and you have the ability to request it be expunged from a written letter to the Department of Justice, not to the court, but to the Department of Justice. I believe that covers everything, Mr. Schmidt.
Nothing from me.
Ms. Landgraf,
No, Your Honor.
Mr. Davis.
Nothing further, Your Honor. Thank you very much.
With sentencing complete, the court has chosen a path centered on accountability and rehabilitation. Aaron Benjamin receives credit for time already served, 2 years of probation, imposed and stayed jail sentences on additional counts, financial obligations, and multiple probation conditions focused on alcohol treatment, domestic abuse programming, and restoring his driving privileges legally. Throughout the hearing, the judge emphasized that the central issue was not simply the individual charges, but the repeated role alcohol played across multiple incidents. Rather than imposing the maximum available penalties, the court structured a sentence intended to encourage lasting behavioral change while still holding Aaron responsible for his actions. The message was clear. Future success depends entirely on following probation conditions and breaking the cycle that brought him back into court. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
Getting this money.
Thank you, Your Honor. Have a nice day.
Thank you, Mr. Davis.
Good morning, Your Honor.
Good morning.
Which day you stand up here?
Well, they need to get going.
Let's see.